All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Thomas J. Christensen presiding.
Please be seated. Good morning. Welcome to the.
Mike, can I do that?
If you would like.
Sorry, Judge Quinn. Difficulties already.
My mute button is on. It's yours right now. See the light?
No,
Only Tom should be on, right?
your mute button should all be on.
Okay.
There we go.
Once again, welcome to the Minnesota Judicial Center for Oral Argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is June 24th, 2025, and we have one case scheduled for oral argument. Case is entitled Jennifer Williams versus Delta Airlines, Inc. and Ace USA with claims administered by Sedgwick Claims Management Services, Inc. Our file number is WC 256497. Today's argument is being live streamed and recorded. We would ask that counsel when presenting your oral argument today to the court, you speak loudly and clearly. The panel for today's argument is on my right, Chief Judge Patricia Millen. On my left, Judge Sean Quinn, and myself, I'm Judge Tom Christensen. We have experienced counsel present today, and as a reminder to each counsel, will be allowed 15 minutes to present your argument, with a yellow light going on when 2 minutes of time remain. Please be aware that we will allow each of you during the beginning of your oral argument 2 minutes of uninterrupted time before I ask the panel if they have questions for you. At the 2-minute mark, I will interrupt your argument and ask if the panel has questions. I ask that counsel keep track of your time. Any unused time may be reserved for rebuttal. Should the allotted time to a party be extended because of questioning by the court, opposing counsel will be also extended a like period of time. When you step to the podium, please identify yourself and the party you represent. And with that, we can begin. Mr. Lagasse.
May it please the court, counsel. My name is Jeremy Lagasse, representing the appellant, Jennifer Williams. It is the position of Ms. Williams that she is seeking this court to review the findings and order of the compensation judge with respect to two particular categories of determinations that otherwise resulted in the denial of benefits. Firstly, with respect to the credibility determinations regarding my client, Ms. Williams, it is her position that substantial evidence does not support the findings of the compensation judge that resulted in her determining that Ms. Williams lacked credibility. With respect to reasonable minds, the standard here, if you review the record as a whole, which this court is empowered to do, to weigh its substantiality, you will observe the inherent contradictions and the misrepresentations of the factual record that the judge otherwise memorialized as the basis for determining that Ms. Williams lacked credibility. The second category is with respect to the expert testimony of Dr. Topliff. With regard to Dr. Topliff's opinions, I would draw your attention to the fact that he departed from the plain language of 176155 inasmuch as he made categorical opinions that were not going to be subject to a proper application of the law. That is, it didn't matter whether he examined my client or not. He was already predisposed to the opinion that causation could not be established. That invokes Hudson v. Trillium, and otherwise, by placing proper objection at the trial level, his opinions should be disregarded and the trial court instructed with respect to the proper application of the eggshell plaintiff doctrine, as well the proper application of the law with regard to occupational injuries, that is occupational exposure injuries. Here, we are looking.
Let me
at- Please.
interrupt you at that point in time and ask Judge Quinn or Judge Millen whether they have questions for you at this time.
Me?
I have no questions
Oh.
at this time.
Oh, okay. I'll ask a question. So, Mr. Legacy, I appreciate your argument regarding Dr. Topliff, and I assume that part of the argument also goes to his failure to apparently review one of the medical records, because he doesn't mention it anywhere in his report, November 13, 2019, where the physician assistant examined your client. She put the uniform on and saw objective evidence of a reaction to the uniform, and he doesn't mention that. That's part of your argument regarding Dr. Topliff?
It is indeed a part, but the substantial argument here deals with, again, his determinations. When you review the plain language of his August 2020 document review, which itself is a document review, 155 says the word examination. It cannot be anything else. At the end of that report, which contains a number of interesting observations, but right at the end, he says sort of cutely that he didn't have the opportunity to examine my client, but he's sure that if he does, it won't change any of his opinions. And that's a problem because the law does not set forth in an occupational exposure injury that pre-existing conditions are insignificant for purposes of determining whether somebody is otherwise more sensitive than the average person to a particular substance, toxin, or hazard of employment.
But you're not saying that record reviews are not allowed to prove one side or the other, or are you?
You know, I'm saying that it cannot be submitted as evidence to have a record review instead of a physical examination. 155 has never been construed to do anything other than permit an employer and insurer to get a physical examination. But that's part of the crux of the problem with the defense in this case. They have attempted to set, with respect to occupational injuries and occupational exposure specifically, a higher standard than what this court and the otherwise body of case law has permitted for decades, which is that you don't have to have a particular cause identified, but the temporospatial connection that the treating physician in this case identifies is sufficient under this court's previous case law. And instead, what they attempt to establish is that they have this higher review, the Intertox report, which, as an aside, I would beg this court to take a look at, because according to Dr. Topliff's opinions, there's no objective evidence, in large part because of this report. And then his otherwise uncited statements that none of the toxins that are contained in these garments could cause someone injury. The report itself identifies its own methodological limitations. That is, it doesn't test for every chemical. It leaves room for the possibility that you have an extra sensitive portion of the population. And then finally, it identifies the limitations of the toxicology discipline in as much as we could determine the hazards associated with chemicals that we all thought were benign in the future.
All right, but let's go past that though. At the very end of her memorandum, the compensation judge wrote, she's aware that your client did not need to show employment to be the sole factor, and implicitly saying something to the effect of, pre-existing conditions aren't a bar to a workers' comp claim, which we all know they are not. But then she said, must show a significant contributing factor. Here, the employee failed to show a direct connection, basically did not meet burden of proof. And so my question then to you is this: let's forget about Dr. Topliff. Let's forget about that tox report. Where is the burden of proof met by your client here?
With regard to the facts in evidence, which are undisputed, my client testified, reported to her doctors specific to the November 12th, 2019 date of injury, that she experienced physical manifestation after physical contact with the V-neck passport plum uniform, took time and date stamp photographs of the symptoms, and then presented to her provider the following day, who actually did an on-site physical observation of her reaction to the same.
And I have a question as you're moving through this before we go too far off that path. And I first want to look at finding 27. Where in the record does Dr. Topliff's identity or identify the November 13th, 2019 chart note by the PAC Steel?
For purposes of the foundation of his report,
Correct,
he does indeed list the provider's records that he reviews.
right?
Dr. Topliff does not cite to this particular date of service. However, he takes as credible the history provided by my client. And that's, I think, one of the fulcrums on which this case turns, is that with respect to Dr. Topliff, he indeed received her narrative history, her expression of symptoms, and the medical records, even if he doesn't expressly identify this very important date of service. And as a result, renders his causation opinion that 3 particular conditions are causally related to her exposure to the passport plum uniform, which was a requirement and a unique requirement of her employment with Delta.
So having answered it, Mr. Legacy, I want to go back to the finding 24, 25, 26, and 27. I believe no one here appealed those findings. And I'm going to jump a little bit in and out. And if you look at those findings, would you agree that a person seeing a skin reaction is observing objective evidence? And I'm going to ask counsel the same question of that reaction. And I'm looking specifically at finding 27 regarding the chart note.
Yes, it is observing one piece of objective evidence. And
that was never done by Dr. Topliff, correct?
correct. And furthermore, I think it's extremely troubling that in his bookend reports, which are, again, document reviews and not a physical examination, he makes reference in each of those to the absence of evidence. And I appreciate that Dr. McKinney brought up this basic logical postulate that the absence of evidence is not the evidence of absence. With Dr. Topliff's reports, he makes these comments that are explicit about the fact that she didn't have any of the patch testing. But
And yet
that's
the compensation judge made 4 findings, including the employee's husband, and they were statements of fact that there was an observation of objective evidence by both the employee, PAC Steel, and her husband of the reaction.
and corroborated even further by the time and date stamp photographs that otherwise are depictions of those observations by the witnesses. And not that they are to be taken independently or as a basis for a particular diagnosis, but they are supportive of the fact that the testimony from those witnesses and the veracity of the information in the medical records is present. It bolsters it.
So when the compensation judge in finding 70, the preponderance of the evidence fails to show the employee was exposed, she's writing findings of fact in 24, 25, and 26 that are unappealed, that show that there's a skin reaction observed, and that's objective evidence. This is why I'm troubled by the compensation judge's decision. That is evidence of the reaction.
Well, in generosity to the compensation judge, I think that part of the issue here is that Delta attempted to move the goalposts in the law. And that's really, I think, at the heart of this, is that the law doesn't hold an injured worker and their expert to the Daubert standard in federal court. This rule.
Should they?
No. If everything else with respect to the rules of evidence is considered to be a guide, then I don't think this should be the one exception that we attempt to follow.
Isn't that a question of the guidance that you use when you move through a standard of review? And in a federal court case with a class action, you can identify the class action participants. But to me, and I'm troubled by this whole case from many perspectives, why would that even be considered a standard of review in a specific work comp injury in Minnesota? Help me out here, because I really am probably not as understanding of the compensation judge's analysis in this respect.
Well, I think it's because it's about the impression of authority. When you read Dr. Topliff's opinions, I mean, he is preaching from the very highest mountaintop as the prophet himself. That's not the standard here. They make Delta attempts to build him up in his credibility, but it's problematic because Dr. Topliff himself admits that he's lacking evidence and information. He admits that he's missing foundation because she wasn't given the patch testing. But if that's the case,
Doesn't he also admit he doesn't have PAC Steele's November 19th
he does.
chart note?
Yes, indeed.
And doesn't he then point it out specifically in one of his reports?
But as he stated when he first got involved in this case, it doesn't matter, and she can never possibly have sustained an injury whatsoever. And yet, again, based on this court's prior precedent, that's not the standard for occupational exposure cases in the state of Minnesota. And I think one of the troubling aspects of this case is when he makes those references to the fact that she never had the official patch testing, regardless of what you want to say about its methodological flaws. If he says that she needs diagnostic testing, pursuant to Diddle v. Northwest Airlines, that should have been categorically approved immediately, regardless of whether the byproduct of that testing demonstrated causation or not. And the record is uncontroverted. They had her approved for this testing, and then it was pulled. And
Isn't the chart note the test on November 13th?
It is a form of test, and to me, it is not the official patch testing. But
I understand that, but isn't that a test?
It is enough to meet the burden of proof here. But if they want to reframe the rules and the standard, they should have permitted it. They didn't, and they should not be protected by their failure to otherwise see the evil and hear it. Thank you for your time.
I know you're out of time, but I want to follow up.
I
So
guess I would,
go ahead.
no, I would
Go
like
ahead.
to.
So going back to my question about burden of proof. So the testimony of your client, the testimony of her husband, the photographs, PA Steele's note. What else do we have that proves a work injury?
Dr.
What-
Dr. Topliff's report.
No, Dr. Topliff is not
Or
helping
excuse me,
him.
Dr. McKinney.
Okay, yeah. All right. So, all right, and you're talking about Exhibit T, the narrative, the long narrative report.
The narrative report from her treating occupational medicine specialist. Yes.
Okay, so here's my question to you about this. Question one from you to the doctor, Dr. McKinney, is what is her diagnosis? He answers that. Question two, what injuries did she sustain as a result of the exposure to the uniform? I'm paraphrasing, but that's basically the question. Not did she suffer an injury, but what injuries did she suffer? And I'm picking nits here, but does he answer the question that she suffered an injury with this answer when he gives it? He describes a lot of things, but I'm troubled reading him saying she suffered a work injury in his answer. I'm struggling with that. I get all the things you're saying about Dr. Topliff, the opposing evidence, but I'm struggling with your evidence because you've got the ultimate burden of proof. Help me with that, with the answer to question two.
Dr. McKinney's opinions lay out the fact that there are 3 diagnoses that are indeed causally related in time and space to her exposure to the Passport Plum uniform. The contact dermatitis, the esophageal reaction, the vocal cords, and her sinusitis. He explains the fact that he has done nonspecific testing, but otherwise is relying heavily upon my client's reporting of symptoms and their connection, again, in time and space to her encounters with this particular uniform product. And part of what I would otherwise bring to the court's attention is that with my client's attempt to be as thorough as possible, that is a unique feature of occupational exposure testimony as opposed to that which would otherwise attend a blunt force acute trauma injury in workers' comp. And it appears as though, again, the presentation of evidence, which is to demonstrate just a significant contributing factor, not substantial contributing factor, but significant, was used against her both by the defense and the compensation judge, and we seek remedy from you. Thank you.
And I know you're out of question. Chief Judge, do you have a question?
I know, before we had talked that you probably had some questions, so I was hoping,
Well, I have one question based on the standard of review that you have before us. Was this case tried simply as an occupational disease case, or was it also tried as a personal injury? Because we have case law within our number of cases where when it's a contact dermatitis case, and as you just said, that's one of the diagnoses of Dr. McKinney, you can try it either as a personal injury case or an occupational disease case, or kind of a combination of the two. And how was the case tried from your perspective on behalf of the employee?
As an occupational exposure case, it made it rather difficult to try to identify with particularity those dates on which the manifestations arose to some sort of peak. And so our argumentation, particularly in closing argument, it was all geared as an occupational exposure injury.
Okay, thank you.
Thank you very much.
Mr. Melland, when you're ready.
Good morning, judges. Good morning, counsel. May it please the court. We're here today because Compensation Judge Pham did exactly what she was supposed to do in this expert-driven, science-based, choice of expert type of case. She weighed the evidence. She assessed the conflicting expert reports of Dr. McKinney and Dr. Topliff. She expressly adopted the opinions of Dr. Topliff at the exclusion of Dr. McKinney. She assessed credibility, and she issued a decision that was founded in substantial evidence. And we respectfully request that the decision of Judge Pham be affirmed. I want to begin talking about the standard a little bit, as Judge Christensen alluded to. This appeal is a Hanging Mule and Nord v. City of Cook type of case. The basis for the appeal is of substantial evidence. It is a foundation for Dr. Topliff's opinion. It's a choice of expert appeal, and credibility determinations. And as this court is well aware, these are decisions that are very often left up to the compensation judge to decide. I know it feels a little weird telling you all that because you know that, but I need to emphasize those standards is what we're dealing with on appeal here. The question here is whether the decision from Judge Pham is supported by substantial evidence when the record is viewed as a whole, and whether the IME, Dr. Topliff, had adequate foundation for his opinions when Judge Pham expressly adopted his opinions at the exclusion of Dr. McKinney. I would note that is Judge Pham's job as a trier of fact, is to make those decisions of choosing between two expert reports and who she believes is more credible and who she chooses to adopt. And I would note that Dr. Topliff, as explained in my brief, I'm not going to rehash it, but he had adequate foundation for his opinions as well. And therefore, respectfully, pursuant to the standards of Hanging Mule and Nord, we would ask that this court defer those decisions to the compensation judge and affirm her decision. And likewise, with regard to credibility, I would note that those determinations are very uniquely reserved for the compensation judge. Judge Pham was in the room with all of us. She heard the testimonies. She saw the body language, the demeanors, the tone of voice. She saw everything, and she compared.
Let me interrupt you at that point. We're at the 2-minute mark and ask whether the other judges have any questions for you.
Absolutely. Let's go to Dr. Topliff's opinion. He says repeatedly in at least one, if not all three of his reports, I lost track, There's no objective evidence of any reaction of the employee to her uniform. And yet we do have this one treatment note, and it is, best as I can tell, it's a singular treatment note, but one treatment note, try on the uniform, 10 minutes later, she's got a rash that she didn't have right before she tried on the uniform. That's objective evidence, I would think. How do we say that, how is Dr. Topliff's opinion properly founded if he's ignoring the one piece of objective evidence that we have?
So I would note, Judge, that if you look at our record review background letter to him, we did note that she was diagnosed with contact dermatitis at that visit by PA Steel. But I would also clarify that Dr. Topliff goes through his reports and he explains that it is impossible for these uniforms to persist giving off these perceived chemicals in perpetuity. Keep in mind, this PA visit was a year and a half after the uniform was released. It would have been washed dozens of times, had perfume on it, lotions, spilled pops on the plane. Just putting it on at a doctor's office in the context of someone who has skin issues for 20 years, admits that she's been allergic or have reactions to detergents, perfumes, what have you. Can you, I would ask a question back, can you show me where it says the uniform is causing that reaction and not something else? Because we have all the data that shows the uniform is incapable of it's no different than any of your other clothing.
Isn't that the whole reason why the evolution of occupational disease came about later? Because what we thought was uncontroverted fact, this could never happen a year later, evolved into something more than a specific injury or even a Gillette, that multiple exposures and the cumulative effect and the individual person in a work comp claim as opposed to a class action, you take the employee as you find her. And therefore, it's not an uncontroverted fact. It's his opinion. And my problem or concern is that the identifiers of a chart note, and again, reiterated by the compensation judge, and Mr. Millen, you did not appeal findings 24, 25, 26, and 27. Those are unappealed findings of fact. The employee's husband testified to what he observed and identified at that point. Now, there was no finding that this was not a credibility issue, either yes or no. It was a finding of fact by the CJ in those findings, as well as the chart note of PAC Steel. That's why I'm having a hard time in finding 70 to talk about the preponderance of the evidence or to identify in finding 68 that the employee is not credible with respect to the nature and cause of her injuries. And my final question, what does that matter? Nature and causation. Aren't we looking at the additional evidence in the totality of your standard of review and not just the nature and cause of a testimonial piece that may have a contradictory statement within the additional evidence?
I'll try and answer this.
I
So-
know that's a lot. I apologize.
No worries. So with regard
Stacking it, I know.
with regard to those findings you referenced, so yes, Judge Pham made findings that those statements were made. She did not say that she made a finding of fact that she had a reaction to the uniform. She said PA Steel made a diagnosis that he diagnosed contact dermatitis. And I want to, I guess,
Don't
elaborate.
you usually compare those then in an analysis tool? If I'm a compensation judge, I then use those and I find those statement not to be true, or I find those statement don't rise to a level consistent with the standard of proof that was necessary. I see none of that. I see findings of fact. And that's exactly what they are, without credibility determinations. And they're unappealed. Tell me how I reconcile that with finding 70.
Give me a moment if you would to pull up finding 70. This is a lot to unpack. And what I'll say, I'll start with the contact dermatitis. Okay. I would note that PA Steel diagnosed contact dermatitis. her own doctor, Dr. McKinney, later in September of 2022 said, no, she doesn't have contact dermatitis, and she never did. So we have PA Steele saying she did. We have Dr. McKinney saying, no, she didn't. And we have Dr. Topliff saying the uniform is not causing any of your symptoms. So we have a he said, PA Steele versus the other two. He said, she said. It's the same, to use an analogy, of one doctor reviewing an MRI report and saying, I see a herniation here. And then an IME saying, well, no, I don't see any herniation here. Okay, both things can't be true.
I don't look at an MRI scan the same way because a herniation is present in that tool. I got a chart note that says there's a timeline that really is a test, and then there's no analysis of whether that test is indicative of the disease that's being claimed.
Yes, I to elaborate on that, and I still go back to this, the theory that's being presented is I cannot tell you what's wrong with the uniform. Even at the hearing, you cannot explain what it is. You just say the uniform caused my problems. And that's okay if one PA diagnosed her with contact dermatitis. My response would be, okay, does anywhere show that or explain how it was the uniform that caused it and not something on the uniform?
So all these symptoms that arise in present analysis at the timeline that these uniform or certain pieces of it are put on and off is just a coincidence or never really happened?
Essentially, yes, that is what is
Which
Dr.
one? For the PAC still never happened? Or it's just a
If he
coincidence?
observed redness and diagnosed contact dermatitis, I would agree that
It doesn't matter what the diagnosis is. I could call it a unicorn. I'm talking about symptoms. I come in, I put on a uniform, and within 5 to 10 minutes, I start to get these symptoms. That's a test for what we want to call it. I'll leave that up to you. But that's a test. What is that? A coincidence?
I would say Miss Williams has a burden to explain how it was due to the uniform and not something else. We know she has a 20-year history of skin issues.
You think her pre-existing condition is relevant?
I think it's very relevant.
And if 20 years later, it's relevant?
I think if she ever brings a claim for an occupational exposure to a uniform in 20 years from now, I think
Would
it
we have
be
said
relevant.
that 10 years ago, the 20-year differential is relevant? It's kind of like the uniform. What time period, you tell me it's uncontroverted evidence that that uniform could not emit any type of chemical that would cause these symptoms. It's not, and you're saying that's an uncontroverted fact. But we really don't know if it is or isn't, do we?
I think the fact that you just said we don't know if it is or isn't
Right.
kind of goes to Judge Phom's decision. She has to choose
Right.
between Delta's evidence, the Intertox report, Dr. Topliff, where we can hold the evidence to show this uniform is no different than the robe you're wearing right now. Chemically, there's nothing in it that is different than any clothes. Okay. Or it's the PA Steel, because we're talking so much about that, and the essentially take my word for it. I can't tell you what's wrong with the uniform argument. And Judge Phom has to make that decision. And
Correct.
she sided with the employer insurer and Dr. Topliff. And while I can certainly appreciate any one of you might found differently at the hearing, I believe based on the objective testing that's been performed, the wear testing, the inconsistencies of the reporting of these claims being just from flight attendants,
She didn't meet her burden of proof.
there's, yes, and I would just say that Judge Phom has to make a decision. And as our brief explains, there is a lot of substantial evidence that she based this decision on.
And let me ask you again, as I asked Mr. Levacy as well.